This time I want to talk about terms that are implied in law. Basically, terms that are implied in law are implied as a legal incident of all contracts of a particular class. A good example of this is Breen and Australian Airlines. In that case, you'll remember from last time, an industrial award provided that the employer must not dismiss an employee in a particular manner that is harsh, unjust, or unreasonable. And the employees argued that this term of the award should also be imported as an implied term of an employment contract. And the High Court in that case said that there was no such implied term. So looking at from the point of view of whether the term should be implied in law, they identified that there was an applicable, definable class of contractual relationship, in that case, employment contracts. Then they asked the next question: is it necessary in order for contracts of this class to succeed or to be effective? Is the particular clause necessary for that purpose? And if the answer to that had been yes, then the term could have been implied in law. However, because the High Court found that it wasn't, in fact they said that if it had been negotiated, it was likely that both sides would probably walk away from it. They found ultimately that it wasn't implied as a matter of fact or as a matter of law. Other kinds of terms or contracts or types of contracts, I should say, where this is an issue. Tenancy contract, for example. There's an implied term that a house that is leased for residential purposes should be reasonably fit for habitation. There's also an implied term that all goods should be of merchantable quality. Now note that terms that are implied by law can be specifically overridden by the private agreement that's reached by the parties. But where we find terms implied by law is this particular term will be implied in all classes of contract of this type. So, where a court is asked to imply a term as a legal incident of a particular type of relationship, the test is whether, having regard to the broader issues of policy, the term is a necessary incident of the particular class of legal relationship. The answer is likely to be that it is, unless such a term is implied that the enjoyment of rights conferred by the contract would or could be rendered nugatory, worthless, or seriously undermined. In other words, the term needs to be necessary in order for terms of this kind to be implied in all contracts of this type. So this slide here basically repeats what I've been saying earlier, and it sits there and does a contrast between terms that are implied by law as opposed to terms that are implied by fact. Terms that are implied in fact are recognised on an ad hoc basis, case by case. They give effect to some presumed intentions of the parties, and the general presumption is against implying terms into written contracts. It's not the role of the court to fill the gaps. The more detailed and apparently complete the contract, the stronger the presumption is that there should be no terms implied. On the other hand, terms that are implied by law apply to all contracts in a relevant class. They don't make reference to the intentions of the parties at all. They're there for efficacy as opposed to working out objectively what the terms or the implications of the parties were, even though they didn't express them. So, as I said a minute ago, they're not based on the intentions of the parties. It's also worth noting that the categories aren't closed and they're continuing to develop over time. If you're implying a term as a matter of law, you need to satisfy those two requirements that I mentioned at the beginning. The term itself or the principle must be applicable to a definable class of contractual relationship, so we need to be able to point to employment contracts, tenancy arrangements, doctor-patient arrangements, trust agreements. And it also must be recognised as a term that's suitable to be implied in all kinds of contracts of that class, so it needs to be necessary. Let me illustrate the term using this case, Liverpool City Council and Irwin. There was a consistent history of issues, many of which were the landlord's fault, in a building that led to several tenants, including Mr. and Mrs. Irwin, withholding rent. The trouble included things like lifts failing, a lack of lighting, unguarded holes in a stairwell, frequent blocked rubbish chutes, basically issues with common areas. The tenants argued that the landlord was in breach of an implied term to keep common parts of the building in repair, properly lighted. There was no express term in the lease itself. Lord Wilberforce held that the landlord must of necessity also have a contractual obligation as to the maintenance of the common parts in light of the contractual relationship itself. It didn't go to what his intention was, it went to the nature of the contract itself. There was an implied obligation to take reasonable care to keep the tenancy or the common areas in the tenancy in a reasonable repair and usability. Another good example is Breen and Williams. This is the often referred to, probably unsanctimoniously, as the boob case. This goes back to the 70s when Mrs. Breen underwent some plastic surgery during which silicone implants were inserted into each of her breasts. As a result of some severe pain that she suffered, she consulted Dr. Williams, who performed a procedure, and he didn't actually remove or change the existing implants. After that, she corresponded with Dr. Williams about the possibility of having implants removed, and he didn't actually do that. It was subsequently discovered that the silicone gel in the implants that she had leaked, and she required some corrective surgery. She became involved later in some litigation against the manufacturers of the implants in the United States. But in order to opt into the settlement, she needed to file some copies of her medical records with the United States courts. So Dr. Williams, though, refused to provide those medical records. So this particular action was about whether or not there was an implied term in the contract that the medical records should be handed over as an incident of the nature of the doctor-patient relationship. When the matter got to the High Court, there were three primary grounds for the appellate's claim that she had a right to access medical records. Firstly, there was an implied term in the doctor-patient contractual relationship that should enable patients to have access to their medical records. Secondly, that patients have a proprietary interest in the information contained in their records. And lastly, that there was a fiduciary relationship between doctors and patients, which requires doctors to provide patients with access to their medical records. Here we're particularly interested in the question of whether or not there is an implied term as an incident of the legal relationship between doctor-patient that patients have a right to their medical records. Again, the same test was applied. Justices Dawson and Toohey said it wasn't necessary for the reasonable or effective performance of the doctor-patient relationship that Dr. Williams should be obliged to give Mrs. Breen access to her medical records. Similarly, Justices Gaudron and McHugh said, so far as advice and treatment were concerned, the only relevant contractual term that was implied by law was the exercise of reasonable care and skill. So she was refused access to the records. Some examples of these kind of terms, you can find them in your textbook, and I don't really want to dwell on them here. They include things like reasonable fitness, merchantable quality on a contract for the sale of goods, a rule that the payment and delivery for goods are concurrent conditions, implied warranties of seaworthy in a carriage contract, where goods are being taken by sea. There's an implied term that the vessel will be seaworthy, and an implied condition on the letting of a furnished house that it's reasonably fit for habitation. Other ones include an implied promise by a servant not to disclose secret processes or disclose information about a client list to competitors, An implied duty of care in the carriage of passengers and looking after bailed goods. Here, a bailed good is goods that are held by a bailee as security for some obligation. So when you hand something over to somebody on the basis that they will look after it, that's the implied term, but they will hold it pending you fulfilling your obligation. So it's a security interest. Note that these days is largely covered by the PPSA, the Personal Securities Act. An implied promise by a banker not to disclose the state of his customers' accounts to other people. In general, a term is necessarily implied into a contract that neither party will prevent the other party from performing it. Makes sense, doesn't it? That the act of doing something or refraining from doing something, which it of itself wouldn't otherwise be a breach of contract, but ultimately causes the other party to breach the contract, really lacks a fairness, or one would expect that when going into a contract that both parties expect and will do what is possible and reasonable to see the contract through to fruition. Whether that is going as far as being a duty to act in good faith is a matter that is under debate. I like this quote here from the case of O'Keefe and Williams. It's from Justice Isaacs. In every contract there is an obligation, implied where not expressed, that neither party shall do anything to destroy the efficacy of the bargain he has entered into. So, where the performance of a contract can't take place without the cooperation of both parties, it's implied that cooperation will be forthcoming from both parties. Recent case, which is in your textbook, or sorry, your casebook in chapter 14 at 158, is the case of the CBA and Barker. This asks us to look at the question of when contractual terms are implied by law. That case involved the question of whether in an employment or relationship there was a duty of mutual trust and confidence between the parties, whether the employer owed trust and confidence to the employee as well as the other way around. The court firstly considered the legal principles relevant to contractual terms that were implied by law, noting that all implied terms that have been accepted into employment contracts in the past, for example, the implied duty to give reasonable notice under an employment contract, are subject to the express provisions of the employee's contract and to any applicable statutes. So this is an area that is highly regulated. For example, the Fair Work Act 2009 deals with these kind of things now. To decide whether the term of mutual trust and confidence should be implied by law, the key question was whether the term was so necessary that without it, the rights of the parties to employment contracts in Australia could be rendered worthless or seriously undermined. And while the courts do have limited lawmaking functions, the creation and implication of broad normative standards, such as the implied duty of mutual trust and confidence, aren't to be taken lightly. So one of the things that we are seeing over and over again in this area is the areas where many terms were previously implied by law, statute has taken over. And where we will see that happen the most is in the area of consumer law. And when I get to terms implied by statute, that's the focus that we're going to have. So in a unanimous decision in Barker, the court rejected the existence of this implied term. They said it's not for the courts to decide these normative standards. If in fact the law is to include such a standard, then it's the role of Parliament to be specific about including it in a statute, or the parties to specifically agree it as a term of their contract. So this leads us to this question which often comes up in exams as a critical analysis question. It's something that you started reading about back when you were reading about topic 1. Is there an implied duty of good faith in Australian contract law? The person who writes most about this is Professor Finn, and he puts some really interesting and I think very strong arguments as to why we need to have that standard. However, myself coming from a transactional contract and probably a classical contract background where the contract is very much the private law between individuals, at the end of the day, I see it very much where there is equal bargaining power as being an option for the parties to determine what level of good faith, if any, they're going to adopt in their dealings between each other. And that this idea of good faith or the utmost good faith brings a level of ambiguity and concern to the interpretation of contracts, which in fact could ultimately bog them down. Open to a range of views though, obviously, and I think it's going to be a really interesting area to see how it develops. Remembering too that it is the role of legislature to propose normative standards. A couple of quotes on this slide that you might find useful as you're thinking about that, but I look forward to, if the need arises, hearing what you have to say. Moving forward, next time I'm going to be talking about terms that are implied by custom.